My sister stole my business, not the customers, not the money, the actual name. She registered it legally, weeks before I could, and suddenly the company I had built from nothing was hers on paper. I thought I had lost everything. Then the county clerk who processed her paperwork looked at me and said something I will never forget. "You were in here first, back in the spring. I remember because I kept your card. My name is Amanda Collins." 6 months ago, I was running a successful branding agency from my apartment. Today, I am fighting to prove I own my own company. Because my sister Jessica filed the paperwork first, 17 days before I could. This is how she pulled it off, and the tiny details she never saw coming. Let me take you back to the beginning. January of last year, I was 29 years old and working 60-hour weeks out of a studio apartment with a radiator that clanked so loud I had to pause client calls whenever it kicked on. I had spent 3 years as a marketing director for a mid-sized firm downtown, but I kept noticing the same pattern. Small businesses, women-owned startups especially, were paying agencies thousands of dollars for brand packages that looked like templates. I thought I could do better. So I started moonlighting. Nights, weekends, lunch breaks in my car. I designed logos on a laptop with a cracked screen and filed my first LLC paperwork by hand at the county clerk's office on a rainy Tuesday in March. Kevin, the clerk, had to help me with the forms because I filled out the wrong line twice. He gave me a stick-on tab to mark where I needed to sign and told me to come back with the filing fee. I remember sticking his business card in the back of the filing. I had no idea that card would matter 6 months later. The first 3 clients came through word of mouth. A bakery in Sheridan, a yoga studio, a landscaping company. I charged $500 per package, barely enough to cover stock photos and font licenses, but I was building something. I started posting on social media, early morning time-lapse videos of my design process. Within 4 months, I had a wait list. By June, I had quit my job and taken the business full-time. I named it Collins Creative Branding. Not flashy, but it was mine. I had vendor accounts, 12 active clients, a contract template I wrote myself, and a notebook filled with ideas for scaling. I was ready to make it official, register the name, get a business bank account, file for trademark protection. I told myself I would do it on July 1st, a clean halfway point in the year. I marked the date on my calendar with a circle. I told my sister Jessica over dinner on June 14th. Jessica is 2 years older than me, 31 at the time. She had bounced between jobs for years, admin assistant, real estate assistant, front desk at a dental office. She always said she wanted to start something of her own, but she never quite followed through. That night at the restaurant, I was excited. I showed her the logo, the client roster, the website mock-up. She asked a lot of questions. How much was I charging? Who were my clients? What was the registration process like? I thought she was being supportive. I even handed her the county clerk's business card because she asked for Kevin's contact info, said she might want to file something someday. I didn't think twice. I trusted her. She was my sister. 17 days later, I walked into the county clerk's office with my completed forms, my check for the filing fee, and a sample of my branding materials. I handed the paperwork to Kevin. He typed the business name into the system, paused, typed again, and then looked up at me with a strange expression. He said the name was already taken. Collins Creative Branding LLC had been registered on June 28th, 3 days before my planned filing date, by someone named Jessica Vance. Jessica Vance is my sister's married name. Kevin said the paperwork had been processed in the morning by a woman who looked like me but a little older. She had handed him the same business card I had given her, with his name on it, and said I recommended him. The card with my handwriting on the back, the one I had stuck in my filing that March afternoon. I stood there at the counter, staring at the screen, and I realized my sister hadn't just stolen my business name. She had weaponized my own preparation against me, and that was only the first thing she took. I called Jessica from the parking lot of the county clerk's office. My hands were shaking so badly I could barely hold the phone. She answered on the 3rd ring, calm, like she was expecting me. I said, "You registered my business name." And she said, "I registered a business name. It's not my fault you were too slow." I asked her why. She told me I had a good idea and she saw an opportunity. She said I could still work for her as a contractor and she would take a percentage. She said it like she was doing me a favor. I hung up and sat in my car for 20 minutes, staring at the dashboard. I had just lost my company name, my legal identity, everything I had been building for months, because my own sister had walked into the same clerk's office, handed over the card I gave her, and filed first. But here is what I did not know yet. Jessica had not just taken the name. 2 hours later, I opened my email and found a message from my longest-running client, the bakery in Sheridan. The owner, Maria, was confused. She said she had just received a new contract from Collins Creative Branding, with a note saying I was now part of a larger team and that all future payments should go to a different account. The email signature was Jessica's name. My sister had gone through my client list while I was at her house for dinner that night in June. She had taken photos of my contracts, my pricing sheet, my onboarding templates. She had sent a mass email to half my client base using a domain she registered that same week, collinscreativellc.com. One letter different from the domain I had been using for 6 months. My clients did not notice the extra L. I spent the next 48 hours on damage control. I called every client. Most were understanding. 2 canceled their contracts on the spot because they were worried about legal exposure. Maria stayed. She said she trusted me. But the damage was real. I lost $3,000 in pipeline revenue before I even understood the full extent of the breach. Then I called Kevin, the county clerk. Kevin answered on the second ring. I expected a bureaucratic wall, a politely worded explanation that there was nothing he could do, that the filing was legal and complete. Instead, he said, "I was hoping you would call." He told me he had been thinking about that day in March when I first came in, fumbling with the forms. He remembered me because I had left my business card behind, tucked inside the intake folder. He kept those folders. He kept everything. He said he had pulled my card from the file after Jessica left, and he remembered something else. I had come back later that same week with the filing fee. He had scribbled a note on the intake sheet, March 19th. Amanda C. returned with check, filing pending signature. He had the date. He had the note. He had my card. I asked him what that meant legally. He said he was not a lawyer, but in this county, a prior filing attempt, even incomplete, created a paper trail that could challenge a later registration if the first person could prove prior use in commerce. I had the client contracts. I had the timestamped branding. I had the domain registration from February. And now I had Kevin. But here is the thing about common law trademark rights. You may have heard that whoever registers first owns the name. That is not true in the United States. Rights come from use, not registration. The first business to actually use a mark in commerce has priority. And I had been using Collins Creative Branding since January. I had invoices. I had social media posts. I had a dozen witnesses. The registration was important, but it was not the final word. Jessica thought filing a piece of paper made her the owner. She was wrong. The problem was proving that would take time and money I did not have. Jessica had already started operating under the name. She had opened a bank account. She was sending invoices. She had even reached out to the same vendor I used for printed materials and placed an order using my brand colors, my font choices, my tagline. This was not just theft. It was identity erasure. She was building a life inside the shell of something I created, and I was supposed to just watch. I confronted her in person at her apartment. I did not call ahead. I just showed up. Her face when she opened the door was not guilty. It was annoyed, like I was interrupting her. I told her about the clients, the domain, the bank account. I told her I had evidence of prior use dating back months. She crossed her arms and said, "Prove it. It's my name on the state registry now. Good luck explaining that to a judge." Then she said something I will never forget. She looked me in the eye and said, "You never understood business, Amanda. You just know how to draw pretty pictures." Someone had to take the idea and actually make money with it. That sentence told me everything I needed to know. This was not a mistake. This was not panic. This was a calculated decision made by someone who had watched me struggle, who had seen my excitement, and who had decided she deserved the result more than I did. I left her apartment and drove to the cabin. Not a cabin like in a story, just a rental I had booked months earlier for a design retreat weekend. It sat on a lake 2 hours outside the city. I spent the night alone, staring at the water, going through my options. I had no lawyer. I had no savings left after the client losses. But I had Kevin's intake note. I had my own records. And I had one more thing. Something I found while scrolling through old emails at 3 in the morning. A time-stamped chain from March 3rd, where I had sent Jessica a draft of the brand name and asked for her opinion on the font layout. The subject line read, "Collins Creative, what do you think?" The date was 3 months before she filed. She had replied with a thumbs-up emoji. It was not a contract. It was not a legal agreement, but it proved she knew. She knew exactly what I was building and exactly what the name meant, and she filed anyway. The next morning, I called a trademark attorney I had spoken to once at a small business workshop. His name was David. I explained the situation. His first question was not about the registration. It was about use. When did you first use the name in commerce? I told him January. He asked if I had any public-facing evidence. I sent him the social media screenshots, the vendor emails, the domain WHOIS report. He said that under common law, I had what is called senior rights. The first user in a geographic area holds priority, even over a later federal registration. He said Jessica's state registration was weak. It was just paperwork. My use was real. He said we could file an opposition, maybe even a cancellation proceeding. But he also said one thing that stopped me cold. Your sister is going to hit back. Are you ready for that? I thought about that question all the way home, because I knew exactly what Jessica was capable of, and I knew the next move would not be hers, it would be mine. And it would start with a single filing at the county recorder's office, a public notice that said my claim on Colin's creative branding was real, and that her registration was based on bad faith. And I was about to learn that bad faith registrations can be challenged, not just in court, in front of a board that exists specifically for cases like mine. Cases where family members, business partners, former friends try to steal what they never built. But there was a catch. That board, the Trademark Trial and Appeal Board, moves slowly. It can take a year or more for a final decision. And in the meantime, Jessica would still be operating under my name, taking my clients, building her reputation on my work. Unless I could get an emergency injunction. And that meant I had to prove irreparable harm. Harm that was happening right now. Not next year. Now. I called David back and asked what I needed. He said, a sworn declaration from someone who witnessed the theft. Ideally, someone neutral. Someone with no stake in the outcome. Someone who saw the dates, saw the intent, and can testify to both. I told him about Kevin, the county clerk who kept my card. The man who remembered the day I walked in with damp hair from the rain and filled out the wrong line. The man who watched my sister file the same name 17 days before my planned registration. The man who still had the intake note with my name and the date, March 19th, before Jessica ever set foot in that office. David was quiet for a moment. Then he said, "Get me that note, and ask Kevin if he is willing to make a statement. If he is, your sister's registration might not survive the month." I hung up and stared at Kevin's card. The same card I had tucked into a folder 6 months earlier. The same card my sister had used as a weapon, and I realized something. She never threw it away. She handed it to Kevin with my handwriting still on the back. She had handed him the evidence of my prior visit without even knowing it. Kevin signed an affidavit the following Monday. It was 2 pages, notarized, detailing the exact sequence of my visits. March 19th, I had come in to start the LLC process. June 28th, a woman he now recognized as Jessica Vance had presented the same business name, referencing me by name and using my card as her reference. He had written a note on his intake sheet that day. Sister of prior filer. He had felt something was off. His sworn statement, plus the time-stamped intake note, gave David enough ammunition to move forward. We filed an opposition with the state's business registry division the next morning, but that was only the beginning. Because the very same week, I got an email from the United States Patent and Trademark Office. My sister had done more than file a state LLC. On July 2nd, 4 days after her county filing, she had submitted a federal trademark application for Colin's creative branding. She claimed a first use in commerce date of February 1st, a full month before my own records began. She had lied under penalty of perjury. And if the trademark application went through, she would have nationwide rights, not just the state. She was trying to take everything forever. I forwarded the email to David, my hands cold. He called back within 20 minutes. "This changes things," he said. "She's not just playing defense, she's playing offense. Now we have to oppose the federal mark too." The Trademark Trial and Appeal Board does not move fast. A full opposition proceeding can take over a year. And during that time, the applicant keeps the benefit of the pending mark. That meant Jessica could keep using the name, keep confusing the market, keep bleeding my business dry while I waited. Unless I could get a preliminary injunction from a federal court. David said it was a long shot, but with Kevin's affidavit, my time-stamped branding records, and the email chain where I told Jessica the name back in March, we had a case for bad faith. He said, "We file an emergency motion, we prove you'll suffer irreparable harm, we get a judge to freeze her activities until the board rules." I told him to do it. The week that followed was the worst of my life. My mother called. She was crying, then angry, then cold. She told me I was tearing the family apart. She said Jessica had a child to support, a husband who was out of work, and I was just single and could start another business. She asked me, "Why can't you just let her have this one thing?" I heard my father in the background, silent. They had always protected Jessica, made excuses for her failures, and now they were asking me to sacrifice what I built so she could keep what she stole. I said no. My mother told me I was no longer welcome at their house until I dropped the case. The next day, 3 of my remaining clients received a formal cease and desist letter from Jessica's attorney. The letter claimed they were infringing on her trademark by doing business with me, under my brand. 2 of them called me in a panic. One said they had to pause our contract to avoid legal liability. I lost another $4,000 overnight. And my sister, sitting behind her new LLC and her pending trademark, was weaponizing the very legal system she had lied to, using fear to strip away my income before the court could even rule. But here is the pivot. My client Maria, the bakery owner, refused to back down. She told Jessica's attorney in writing that she had been working with me since February, that I had designed her logo, her menus, her entire brand before my sister ever filed anything. She sent screenshots of our early email exchanges, dated February 23rd, showing drafts I had sent her. She said she would testify. And she posted a public message on social media, tagging both my original business page and the fake one Jessica had created. "I know who built my brand," she wrote. "It was Amanda Collins, and no legal paper will change that." The post got shared. Other clients began to speak up. The story started spreading, not just among small business owners, but in legal circles who saw a clear case of trademark fraud. And then, on a Thursday morning in August, the mail carrier delivered a certified letter from David. Inside was a copy of a notice of opposition filed with the Trademark Trial and Appeal Board, referencing my senior common law rights, Jessica's bad faith, and the county clerk's sworn affidavit. Attached was a motion for an emergency injunction, filed in the district court, requesting a halt to all of Jessica's operations under the Collins creative name while the board case proceeded. The hearing was scheduled for September 4th. I spent the next 3 weeks preparing. I gathered every invoice, every design file with metadata, every date-stamped email, every social media post. I printed screenshots of the March 3rd email where Jessica had responded with a thumbs up to the name she would later steal. I prepared a timeline so airtight that even Jessica's own attorney, when we finally sat across from each other in mediation, grew quiet. The mediator asked Jessica directly, "Can you provide any evidence of using the name in commerce before March 19th, the date of Ms. Collins's intake note?" She could not. Her entire claim of a February 1st use date was a fabrication. The mediator recommended the injunction be granted, but it was not over, not yet. The night before the hearing, my phone rang. It was Jessica. Her voice was different, not defiant, not angry, scared. She told me the legal fees were piling up. Her husband was furious. Our parents were fighting. She asked if we could make a deal. She said I could have the name back if I paid her $5,000 to cover what she had spent on registration and legal filings. I almost laughed. Then I realized she was serious. She was trying to sell me my own business. I said, "I'll see you in court." And I hung up. The next morning, the courtroom was small. Just a judge, a court reporter, and the 2 attorneys. Kevin was there, dressed in a button-down shirt, his affidavit in hand. Maria sat in the back row, nodding at me. Jessica arrived late with dark circles under her eyes. The hearing lasted 90 minutes. The judge reviewed the timeline. He read Kevin's statement aloud. He looked at the March 3rd email with the thumbs-up emoji. He looked at Jessica. Then he said, "I don't find a factual dispute here. The applicant registered a mark she had no right to in demonstrable bad faith. The injunction is granted, effective immediately." Just like that, Jessica was legally prohibited from using Collins' creative branding in any commercial activity. Her website was ordered to be taken down within 24 hours. Her bank account under that name frozen. Her federal trademark application, now opposed, was effectively dead. And I, for the first time in months, could finally exhale. But I wasn't done, because the registration was still on the books. and I wanted my name back. The final step would be canceling her registration outright and reclaiming what was always mine. That journey was about to reach its end. The cancellation took longer than I expected, but when it finally arrived, it came on a single sheet of paper. I was sitting at the kitchen table in my apartment, the same table where I had designed my first logos, when David forwarded the email. The Trademark Trial and Appeal Board had entered a final judgment. Jessica's federal application was refused registration. The board cited her bad faith, her fabricated use date, and the overwhelming evidence of my prior common law rights. The decision was not close. 5 days later, the state business registry sent its own notice. Her LLC registration for Collins Creative Branding was canceled, retroactively voided as of the filing date. The name was officially mine again. I did not call Jessica. I did not need to. She received the same notices, and she knew what they meant. Within a week, her website was gone, the bank account frozen. The invoices she had sent to my clients were all voided. Maria called me that afternoon. "I told you," she said. "No paper will change who built my brand." She placed a new order for a seasonal menu redesign, and I sent her the invoice from my real business account, the one I had finally been able to open under the correct name. The feeling of typing Collins Creative Branding into that bank form and having it accepted was something I will never forget. A few days later, I went back to the county clerk's office. Kevin was behind the counter, sorting a stack of filings. When he looked up and saw me, he smiled. "Heard the good news," he said. "Figured you'd come back." I handed him 3 things. A new LLC filing for Collins Creative Branding, correctly this time, a certified copy of the cancellation order, and a small box of pastries from Maria's bakery. He took the box first. "I don't usually accept gifts," he said, "but I'll make an exception." He set my new registration on the counter, stamped it, and slid it back to me. "This one ought to stick," he said, "because this time the person filing it actually owns the name." I still have that stamped receipt. It is framed in my office, next to the original business card I gave him in March. The bigger surprise came later that month. After the cancellation was final, I discovered something Jessica had done that I never anticipated. At the height of her scheme, she had approached a regional branding agency about selling Collins Creative Branding as a turnkey business. She had given them access to my portfolio, my client list, my entire body of work, presenting it as her own. The agency never bought it, but one of the principals recognized my work from social media. He emailed me to ask if I was affiliated with the woman who had pitched him. That email, together with the agency's internal notes on the pitch, became the final piece of evidence that convinced the Trademark Trial and Appeal Board. Jessica had not just stolen my identity. She had tried to sell it, and she had done it all in writing. That revelation ended any remaining hope of family reconciliation. My parents stopped calling. My father sent one text, 2 words, "You won." As if this were a contest. As if I had not spent months fighting to reclaim what was already mine. I stopped trying to explain. I stopped trying to make them understand. I realized that some people will always see boundaries as betrayal, and there is nothing you can do about it except hold the line. In October, I signed a lease on a small studio space downtown. A real office with a window and a door that closes. On the morning of the move, I stood on the sidewalk with a drill, a level, and the sign I had designed months earlier. Collins Creative Branding, in the exact font I had chosen that January night on my cracked laptop. I hung it above the door, stepped back, and looked up. The sky was clear. The street was quiet. I thought about my grandfather, who was not part of this story, but whose words I carried anyway. He used to tell me that property is just a piece of paper until someone builds something on it. My sister had the piece of paper. I had the building. And now, after everything, I had both. I am not the same person who walked into the county clerk's office that rainy Tuesday in March. I am harder. I am more careful. I no longer hand out business cards like they are nothing. But I am also certain of something I was not certain of before. The law is not just a shield for people who file first. It is a shield for people who show up, who do the work, who leave a trail. I left a trail. Kevin kept it. Maria defended it, and that trail led me back to my name. There is one last thing. The morning after I hung the sign, I received a letter in the mail. It was from Jessica. I almost did not open it. When I did, I found no apology, no acknowledgement, just a single line. "I hope it was worth it." I set the letter down, walked outside, and looked at my sign again. Then I answered her, not in a letter, but to myself. Yes, it was worth it. Every hour, every dollar, every painful conversation, because it was never just about the name. It was about the principle that what you build belongs to you, and if someone tries to take it, you fight. Not because you are promised victory, but because you are the one who built it. And that means something. That means everything. Here is what I want you to take from this. The law in the United States does not automatically protect the person who files first. It protects the person who built something first. Use in commerce, actual work, real clients, a paper trail. Those things matter more than a registration date. My sister walked into that clerk's office thinking a stamped form would make her the owner. She was wrong. And if you are building something right now, a name, a brand, a body of work, I need you to know this. Keep your records. Date your files. Save your emails, because your proof of work is your proof of ownership, and you may need it one day. I also need you to hear this part. The hardest part of this entire experience was not the legal fight. It was realizing that someone I loved, someone I trusted, saw my creation and decided it should belong to her instead. That kind of betrayal changes you, but it also clarifies things. I know who my real allies are now. Kevin, the county clerk who kept my card. Maria, the client who refused to back down. David, the attorney who fought for me like it was his own name on the line. They showed up. And because they did, I still have my business. So I want to ask you something. If someone you trusted tried to take what you built, would you fight? Have you already had to? Tell me in the comments. I read them. If this story stayed with you, share it with someone who needs to hear that what they build is worth protecting. Hit that subscribe button if you want more real stories about business, betrayal, and the law that actually governs both. I would be honored to have you here. Until next time, keep your receipts and guard what you build.